Okay, good afternoon, everybody. I hope you can hear me all right. I'm just going to come away from this a minute so I can see where we're up to. Okay, I don't think quite everyone's joined yet, but I'm going to make a gentle start with some basic introductions, and then as people join, hopefully they can join us as we go. My name's Ella Anderson. I'm part of the public law team at Spire Barristers. I work predominantly in health and welfare matters. In terms of the rest of the team, you may be aware we're lucky enough to have a silk at Spire Barristers doing court of protection work with Jackie Thomas. We also have Laura Twist, who's just returned from a period of leave. We have Barbara Green, Sharon Tappin, and Pippa Pudney. We also have a fairly new addition to our team, which we're very excited about. Holly Littlewood has recently come back to the independent bar after a period of time as an in-house counsel at a local authority. So it's great to have another person doing this work with us. The purpose of today's seminar is to give you really an overview of not just the law, but the process surrounding Section 21a challenges. Look at some of the key cases, but also try and give you some practical tips, particularly for social workers and those producing evidence in these cases. And for solicitors, I hope this gives you a bit of an idea as to the sorts of things you might want to discuss with your clients. Dave, I've just had a message that some people can't get into the seminar, so I don't know if there's an issue. But I'll leave you to try and resolve that. So what's it all about, Section 21a? It applies where there is an urgent or standard authorisation of a person's deprivation of liberty and where that's been granted in accordance with Schedule and A1. I'm sure many of you are familiar with some of these basics, so I'm not going to spend much time on it at all. You'll be aware that Schedule A1 provides a statutory framework to authorise deprivations of liberty in care homes and hospitals, whereas at the moment the court needs to authorise community deprivations of liberty. So that's what we're talking about. We're talking about challenges to those standard authorisations. In terms of the statute itself then and Section 21a, this is the law, and it's worth going back to the law, and that's exactly what Mr. Justice Hayden did in the recent case of DP in Hillingdon, which we'll talk about in a moment. But these are the powers of the court. So where a standard authorisation has been given, the court may determine questions relating to, you can see there, the qualifying requirements, the period and purpose of the standard authorisation, and the conditions to which that's subject. You may see in some applications that all of these issues are raised. So we're making a challenge that the qualifying requirements aren't met, and we're also challenging the period, purpose and conditions. I'm going to talk a little bit about statements of facts and grounds and so on in a moment, but in reality, the vast majority of cases are challenging the actual qualifying requirements. There are 6 of those which you're probably aware of. And again, the vast majority of cases deal with the mental capacity and the best interests qualifying requirements, and the others don't really get a look in the majority. So just talking briefly about the standard authorisation itself, and I'm talking here really about the forms. And I do want to touch on capacity assessments within standard authorisations. You may be aware that the quality and depth of these assessments varies quite significantly across the board. And unfortunately, it's my experience that when we have a mental capacity assessment in a Form 4, there's often a rather broad brush approach. And I think we've all seen cases and forms where the assessor simply says, oh, P couldn't understand the information, full stop, next box. P couldn't retain the information, full stop, next box. I think we can all agree that that's entirely insufficient when looking at the mental capacity requirement. In my view, social workers and best interest assessors actually do the job much better, and there's often evidence that they've tried to apply the principles, they've tried to address some of the issues and then gone on to provide their views. Unfortunately, I think that there's still some difficulties with these assessments, and it's a real shame because you can see that the work has been put in. It's not quite come through when the assessment's then been written up, and it does seem to me that there's something to be done around capacity assessments, because when it comes to these challenges in court, the better the quality of evidence, and particularly the capacity evidence at the outset, the much more straightforward the whole proceedings are likely to be, fewer delays and so on. But we'll talk about that a bit more in practical tips in a little while. I do want to just mention also conditions. It always surprises me how seldom conditions are used or applied to standard authorizations. And my view is that there's nothing to fear in terms of conditions, and they can actually be quite useful tools. For example, if an assessment's being carried out by a BIA and it's already apparent that there may be an issue around objection, it's entirely appropriate at that stage for a condition to be added that the managing authority to keep a record of when P is objecting and so on. There's no need to wait to see if that develops, or is it going to be a problem, and then it's added as a condition throughout the proceedings, or the care home's asked to make a note. If that's an issue at the outset, it's entirely appropriate to set that out as a condition from the outset, because that will also assist RPRs and the local authority in terms of looking at the objection going forward. So the application itself, who makes it? Ordinarily, and one might expect, it's the RPR. Occasionally, you get a family member, although that's very unusual unless they themselves are the RPR. And of course, the local authority can make the application as well. Format of the application is a COP-DLA form with facts and grounds in support. So just looking very briefly at how the application comes about. And these are cases you're probably aware of, but I just want to give you a bit of a reminder. So in terms of the RPR making an application, it's the case of RE-RD and others from 2016, case heard by Mr. Justice Baker. And he set out guidance as to when the applications ought to be made. And in simple terms, he set out two main routes. The first being that where P themselves wants to bring an application to the court, then the RPR has a duty to ensure such an application is made. End of story, full stop. The RPR is not required and shouldn't start analysing whether actually it's in P's best interest to do so. If those are P's wishes, the duty is engaged. Of course, it's not always as simple as that, and P is not always able either to communicate or to articulate that they want to challenge their deprivation of liberty. And so the RPR is tasked also with trying to ascertain what P's views would be, for example, if they could communicate, or is their behaviour actually indicating an objection. And there's further guidance within the case which refers to matters such as attempting to leave, packing bags, that sort of thing, although RPRs are also cautioned in terms of could there be another reason for that? Could this be a manifestation of their mental disorder? So the RPRs are in a position where they're trying to make a judgment as to whether P is in fact indicating a wish to challenge their deprivation of liberty. Just while we're on this slide, Section 39D IMCAs, it's always worth just pointing this out and reminding ourselves of this, I think. A Section 39D IMCA is appointed where the RPR is unpaid and, as I say, likely to be a family member. It's the supervisory body's role to instruct such an IMCA in certain cases where P makes a request, where the RPR makes a request, but also where the local authority as supervisory body has reason to believe that without that appointment, then P and the RPR are not going to be able to exercise the relevant rights, or they fail to when perhaps they ought to or might have been expected to. And it is just worth remembering that that is the duty on the local authority. So if you have got a case where a family member has been appointed, my advice would be just to bear that in mind. Do they actually need this additional support? Should an application really ought to have been made and it hasn't been, just keep half an eye on that. The second route then in RD is if the RPR themselves considers that the qualifying requirements are not met or the purpose periodic conditions are not in P's best interests, then it's right for them to apply in those circumstances. And conversely to the previous occasion, this is when the RPR needs to consider whether that would be in P's best interests. A couple of other points, again, it's always useful to just remind ourselves of. There is no need for P or the RPR to show any kind of prospect of success when they make an application. The case of Waite in UK is clear. Article 5 is there. There's an unqualified right of access to the court. Baker also went on in his case of RD to talk about people not being discouraged. And I think this is where sometimes there's been a little bit of uncertainty, because on the one hand, Mr. Justice Baker said that he would hope that it would be possible to resolve concerns around doles informally. But then he also says repeatedly, but people shouldn't be discouraged. So I think sometimes there's a little bit of uncertainty as to whether applications ought to come in. And it does surprise me how seldom Part 8 reviews are utilised in these sorts of circumstances where perhaps there's a concern which could potentially be resolved. But it tends to be that people now are using the court route rather than that. But again, it's always something to explore if you think it's likely to be an issue. Is a Part 8 review appropriate? Is it something to discuss with the RPR? Might that resolve the issue? So we talked about when the RPR makes the application. The local authority, though, can't rely on that as an absolute. This is another case of Mr. Baker actually predating VRD. And what he said was, it's, as we know, the local authority to monitor whether the RPR is representing and supporting P in accordance with their duties. And that is on the local authority to ensure that's happening. And that takes us back to the previous slides around where the local authority feels that the RPR or the IMCA are not doing that, then they need to take steps to address that. And it was said in AJ that where the RPR IMCA has failed to take sufficient steps to challenge, then the local authority ought to consider bringing the matter. And this is a quote from the case of Ria AJ, which was in turn quoting Peter Jackson from the case of Near in Hillingdon. There is an obligation on the state to ensure that a person deprived of liberty is not only entitled but enabled to have the lawfulness of their detention reviewed speedily. And I would just remind you all of that, because I think there is an expectation, understandably, that RPRs will bring these cases, but it doesn't always happen like that. And I think we've all seen the case law and been involved in cases where the local authority has ended up coming under criticism for being aware of objections and waiting essentially for the RPR to bring an application. in my view, there's nothing wrong with you as the local authority discussing this with an RPR, saying, well, it looks like P is objecting, are you intending on bringing an application, and actually having that dialogue. What I'd say though is, if you are concerned, and if there is a clear objection and you're not seeing an application coming through, you are under a duty to bring it to the court's attention. And if you don't, and the delays come and come, then you will ultimately be criticised for failing to do so. So the court's role then in terms of section 21a, I think we're all aware, I hope, of the Vice President's decision, Mr. Justice Hayden in DP in Hillingdon from last year. And essentially he restated the law, and I think I have to concede that perhaps practitioners had fallen into certain practices that weren't strictly in accordance with the way in which the statute is drafted, and I think that's part of what Mr. Justice Hayden was getting at. He made it clear that, you know, the discrete scope and ambit of section 21a applications is for the court to determine whether the qualifying requirements are met. However, there's always a however in these cases. Having said that, it is important to remember that once a section 21a application is made, that doesn't mean that those are the only issues that the court can look at. There's the old case of Mr. Justice Charles in RUF, but actually Mr. Justice Hayden himself restated this again in a case from the beginning of this year, a case of UR, when he said that once an application is made under section 21a, the court's power is not constrained to determining the question of whether P meets one or more of the qualifying requirements. The court also has the power to make declarations under section 15 around capacity to make any decision. And once such a declaration is made, so we know the court has the power pursuant to section 16 to make decisions on P's behalf. So I think Mr. Justice Hayden was trying to refocus attention in terms of section 21a cases, but has also taken the time to remind us that that doesn't mean you can't then look at other issues. And the reality is that other issues do arise, issues around contact, social media, sex, and so on. But I think, as I say, he was trying to refocus us. One of the key things that Mr. Justice Hayden said was the court doesn't take over the responsibility for the deprivation of liberty. I think that's an important point, because with the extension of standard authorizations, which I'll come on to, and the way in which we used to phrase orders, it did feel that that's sort of what was happening. But that's not the reality. The standard authorization is the authority for the deprivation of liberty, and the making of an application doesn't alter that. What, as I say, I think is slightly greyer is what that means for extending standard authorizations, because as we saw in the statute, and as we heard from Mr. Justice Hayden, that the power under section 21a to discharge or to vary arises after the court has determined the application, if you like. So I think there is a question mark as to whether it's appropriate for the court to be varying the standard authorization prior to actually determining the issues in the case. Now, as I say, I think it is a grey area. I think there's different views on it. Certainly at the beginning, I think local authorities took the view that they probably couldn't have them extended anymore. And in my experience, local authorities have been very proactive, ensuring that even where there are fairly short standard authorisations, they are being renewed through the proper processes. However, having said that, the courts that I've been before have been willing to extend them. And so I think until we've got an absolute definitive answer on that, I think it's going to be in the hands of the judges. Of course, it's always preferable for there to be fresh or renewed standard authorisations for all kinds of reasons. in these sorts of cases, it may be that P is being visited by numerous people, OTs, their own solicitor, being assessed by different types or various care homes, and the additional assessment process that a standard authorisation process requires can be slightly overwhelming. And so it can be useful from P's perspective to have the standard authorisation extended. But it can also be a benefit, as I say, of renewing it, because you're then getting fresher evidence. And if there are question marks around the capacity evidence, for example, it's an opportunity, unless you use a previous one as an equivalent, of actually providing further and more up-to-date capacity evidence, as well as best interests, which will take into account wishes and feelings, views of others, and so on. So as I say, I think until there's a more definitive position, you're going to be in the hands of the individual courts and judges. Carrying on Hillingdon then, it's for the court to decide how and when to resolve the issues raised in the application. And this was raised because of the whole interim capacity declarations and interim orders point. Those of you that have been doing this work for any length of time will know that for years we have been drafting orders in Section 21a cases with, and it is declared pursuant to Sections 15 and 48 of the Mental Capacity Act that P lacks capacity to conduct these proceedings and make decisions about residence and care. And we were just doing it as a matter of course. And in Hillingdon they said, well, actually you can't do that. Section 48 isn't drafted in that way. So don't. And so we've stopped. And what we're doing now is generally including a recital in the order, which records that the court considers that there is evidence to believe that P lacks capacity. So it's being done in a different way. Where interim measures are possible is in respect of orders. And where this comes into play most significantly is in respect of obtaining further evidence. Now, of course, Article 5 provides that there should be a speedy review of the lawfulness of someone's detention. And I think we all know that Section 21a cases, with the best will in the world, are not speedily dealt with, unfortunately, for all kinds of reasons. And we've probably all got cases that have been going on for a year or more. But it seems to me that the court is going to be very slow in discharging a standard authorisation at a very early stage, for example, on a first or potentially a second hearing. The court is, of course, always faced with the dilemma and balancing act of autonomy and protection. But even some very recent cases, some of you may have seen the Open Justice commentary on a recent case referring to Mr. B. There was quite clear evidence, or what appeared to be compelling evidence, that P actually had capacity. But in that case, Mr. Justice Cobb, although being invited to discharge, was not keen to do so and ordered further evidence to be provided. So although I think it's likely that there will be more applications for early discharges on P's behalf, I do think that courts are continuing to be quite hesitant about that. Again, going back to Hillingdon, one of the submissions made was that it should be dealt with very quickly, and it's almost essentially on the information you've got, so on the papers, which is what the supervisory body has already done. And Mr. Justice Hayden wasn't really convinced by that. He felt that there should be a bit more than that. So I think that we are going to be under pressure to deal with things more quickly. I think the courts will probably allow the parties to obtain further evidence. But in my own view is that we are going to be under pressure to curtail these very long sets of proceedings. Very briefly then, I just want to look at the paperwork. As I've said, there's the standard form and then the statement of facts and grounds from the applicant, whoever that might be. As I say, you will sometimes see these documents from P's solicitors, which purport to challenge all factors raised in section 21a, the qualifying requirements, purpose, period and conditions. But they should really particularise what the challenge is, and particularly where challenges are being made to the capacity and best interests requirements. I would hope and expect to see a cogent argument and analysis of what is lacking, or what is said to be lacking in the evidence. If it's the local authority making the application, obviously the facts and grounds are going to be a little different. And in those situations, what you would tend to see is the law being set out, but rather the local authority setting out, this is why we say the qualifying requirements are met, and it'll essentially be pointing to the evidence within the standard authorisation forms, but highlighting why the application is being made. So, for example, the social worker has received notification or has visited P, and it's very clear that she's objecting, although the RPR has been made aware no application has been forthcoming, for example. Or what's perhaps more common is where there's a family dispute, where there are family members who have differing views as to what's in P's best interests. Perhaps one thinks that mum should stay in the care home, another thinks she should move back home or move to extra care housing, or indeed come and live with them as an individual. And that might be a more common situation where the local authority finds itself making the application, because the P herself or himself is not actively objecting, but there are questions being raised, and family members asserting that actually the arrangements are not in P's best interests. And most family members won't understand the nuances of the application process and what it all means. And so it may be that the local authority needs to make the application in those sorts of circumstances. So at the very outset, the form provides that the DOLS forms essentially are provided, the care plan is often requested. And when the application goes in, an initial order ought to be filed at the same time. Now, there are what I would call fairly standard first directions orders, which just ensure that standard information is provided, perhaps previous standard authorisation forms, that sort of thing, the current care plan. You can, of course, tailor your initial directions order to provide for whatever you want, and it might need to address issues like party status. I'll just talk briefly here about the CCGs. I would always advise clarifying from the very outset, is the CCG involved? Is this a section 117 case? Is it a CHC case? Is it a joint funded placement? Identify that from the outset and take a view or liaise with your colleagues as to whether it's necessary for the CCG to be joined. I think we all know that the likelihood is that the local authority will be taking the lead. The CCG is more likely to be not a silent partner, but allowing you to take the lead, or taking part rather in joint funding panels, but they don't really want to get involved in the proceedings themselves. But that's the sort of thing that's quite useful to include in an initial order, so that the court and the parties are aware the level of involvement, whether there's likely to be an issue, do we need to spend time trying to join a CCG or whatever. That's the sort of thing that's quite useful, I think, to deal with at the very outset. Something I have seen a few times is where local authorities have tried to be really proactive, because for those of you that have done this for a while, you'll know this. There are some cases where you can see the steps that need to be taken. Do we need more capacity evidence? We're going to need to do an options appraisal. Right, let's just get it all in the first order. So let's put in provision for the social worker to provide a statement that sets out what the available options are with a best interest analysis. Now, on the one hand, that is really proactive and really positive. The only downside with it is that you could have gone to all of that work and then you get to the first hearing and P's representatives say, well, we haven't spoken to P yet, so we don't know their views on this. So we don't know if that best interest analysis fairly reflects their wishes and feelings. We don't know this, we don't know that. And what they also might do or say is, well, we don't agree that that is the type of care that's needed. You haven't looked at this, or you haven't looked at that, or what about extra care, or what about something else? And there's always a danger then that your social worker is having to repeat that fairly onerous task. And so although a lot of the groundwork will have been done, they're doing two statements. So I think it's a judgment call. I think it can be useful in some situations, but I would just caution that if there's any doubt, you may want to wait to the first directions order, which I'll come on to in just a second, where it's agreed. So you've got your initial order, which will list the first hearing, let's get the disclosure of the old forms, etc. And you're supposedly, oh sorry, no, this is that order I just talked about, isn't it? Yeah, so that's inviting the draft file of the application, notifying the CCG, etc. Yeah. Just one thing I want to say about the official solicitor and the ALR. The official solicitor, of course, is litigation friend of last resort. And the official solicitor is becoming a bit more strict about applying the criteria, and you'll have seen, I hope, and if you haven't, I can provide the link for it, some actual guidance that's come out from the official solicitor as what they expect when people are looking to appoint them. But there is, as you may be aware, the greater use now of ALRs, accredited legal representatives, and quite a few COP solicitors are now taking this on. And although the guidance talked about ALRs being used in just sort of fairly straightforward cases where you don't need expert evidence and this, that and the other, we are starting to see a bit more confidence, I think, both amongst ALRs themselves and amongst the courts, the various courts, allowing these appointments for perhaps slightly more complex cases than might initially have been thought. But those are the sort of preliminary issues that will need to be dealt with in that very first order. And just to make the point on that, of course, the Hillingdon case was an ALR case, it wasn't an OS case. So the first hearing then, that initial order is listed a hearing. It is largely administrative and it is often vacated with agreed directions, and this is what I'm talking about in terms of that identification of the work that the social worker ought to do. So what you will hopefully have done is everyone's on board, the parties have been sorted, or you know where you're going with the parties. It's obvious now what evidence is needed. All right, so we want any capacity assessments you've done about this over the last 12 months, for example, and we want standard disclosure. So again, what you'd expect to see is the local authority providing social care records for a reasonable period of time. I would say you can be realistic about that. Sometimes you get requests from P's representatives for social care records for really quite a significant period of time. And I think, you know, local authorities are perfectly entitled to push back on that where it's appropriate and say, well, can you explain why you need 2 years of records? Because it might just be entirely unnecessary. If the issues have only arisen in the last 6 months, or there's been a catalyst 6 months ago, why are you not just going back 8-9 months? And what I always say is start with a shorter amount, and if it becomes apparent that further disclosure is needed, or you do need to go further back, then that can be requested in due course. But there's it's very front loaded for local authorities, disclosure, all this evidence that we'll talk about, and my advice would be you don't have to agree to everything. Is it proportionate? Is it necessary for the case? Can a shorter time frame be agreed at this stage with provision to apply for further disclosure if required? There'll often be third-party disclosure orders against the care home for their records, potentially against hospital trusts or the GP for their records. So additional capacity evidence. Now this is, I do want to talk in the practical tips section about capacity evidence because I think it's really important. And this is what I'm saying about saving time. If those capacity assessments or that capacity assessment within the standard authorisation forms itself is deemed inadequate or lacking in some way, it's more work here. We were going through a stage where it was Section 49 orders for everything. Let's just get a Section 49 order from the relevant NHS trust to address capacity. On that, just so I remember the practice direction. If you're seeking it, you need to follow the practice direction in terms of liaising with the trust in the first instance to get timescales and so on. If it's not you that wants it, it's the other side, make sure they have, because it's on them to do that. The problem we've got at the moment, partly because of the pandemic, but I'm not going to pretend it's only because of that, because we were starting to see the timeframes quoted for Section 49 orders really ramping up, but even before that, you can easily be waiting 16 weeks now for a Section 49 report easily. And understandably, the parties and the court are very unhappy with that. And again, it's going back to the speedy review of detention. And so the court is looking for alternatives to that route. Now, sometimes it is necessary to appoint an expert. And I've had a few cases where the court's been willing to appoint an expert almost primarily because of the delay that failing to do so would cause. But in the majority of cases, there's more discussion around, well, what else can we do? Can the social worker do another one? Is there someone else within the local authority that can do one? So this is what I'm saying about you're potentially saving yourself work and delaying the proceedings if that initial capacity assessment within the Form 3, for example, is robust. In terms of other things that will be looked for at that first hearing, the basis for any restrictions or any other issues, if there's contact issues, for example, and as I say, the options analysis. This is what I'm talking about in terms of, do you want to try and preempt it, or do you want to wait till this first hearing that may or may not be attended and necessary to liaise with the other side about, right, what is it that you're saying P wants? What is it that you're saying ought to be explored? Is this a case of it's going home or nothing? Or it's, we want to explore, all possible types of accommodation in the community. Is it limited to just extra care? Is it, setting the parameters at this stage so your social worker knows what they're looking at. But when I say that, I think it's important that you get clarity from the other side so you don't end up putting yourself in the position where they can just keep coming back and saying, oh, well, can you look at that? Can you look at that? There needs to be some definition. This Section 21a is not there to just start off a fishing expedition or a, let's see how far we can cast the net. Oh, I've just thought of something else. This is about reviewing whether the qualifying requirements are met. Is the best interest qualifying requirement? Is it necessary and proportionate for this person to be a detained resident in this care home? Yes, there may be alternatives that we need to look at, but we've got to do that refocusing down onto the issues. So I do want to move on to talk about some more practical tips. And I know I've banged on a bit about the capacity assessment, but as I say, I think it's obviously absolutely fundamental when we're talking about anything to do with the Court of Protection and Mental Capacity Act. But in terms of these proceedings, it really shortens and focuses the issues and the minds of all involved if capacity can be dealt with at an early stage. So in my view, it is important to explain the purpose of a capacity assessment. Again, you may recall from the Hillingdon judgment, Mr. Justice Hayden talked about the need really to explain the purpose. of an assessment, and that's relevant for a number of reasons. Partly because how is a person to understand the importance of what's going on, the importance of that conversation, the need to engage, if they don't really know what it's about? Is this just someone else coming to talk to them? They need to be aware of what this is about. I'd also say it's really important to, within the assessment document, identify what you think the relevant information is. Again, it's trying to avoid these broad brush statements of, P didn't understand the information. Okay, what was the information, first of all? And of course, we need to remind ourselves always of the principles. It's I think, good practice to set out the principles, which most BIAs do, I have to say, when they're doing a capacity assessment within a Form 3. They do talk about the presumption of capacity, and the need to take all practicable steps. And that shouldn't just be lip service, and I'm not suggesting that it is, but if you can demonstrate that that's been taken into account, I think that's really useful. One thing just to touch upon in terms of the presumption of capacity is this. I feel like I've seen quite a lot recently statements within capacity assessments like, P couldn't or P didn't demonstrate that she understood. I have a bit of a problem with that, because it's not for P to prove to you that they have capacity. The presumption is that they do have capacity. So if you're concluding that they don't, why have you come to that conclusion? What has P said that makes you think that they don't have capacity? It's got to be that way round. And I think that's just, I think I know where assessors are going with that, but I think the language is unfortunate, and I think it's important because it does tend to flip almost where the burden lies. Again, when you're talking about using and weighing information, have you included reference to unwise decisions? How have you satisfied yourself that they can't use and weigh because they couldn't recognise, or they didn't recognise that this was a risk, or they didn't understand that this was their condition, as opposed to, well, they weighed up the information, but they're coming to a bad decision about it. You know, they've weighed those factors differently to the way that you or I might. So I think references to those sorts of points are really useful and really show that the assessor has started from the point of the principles, has applied those principles, and has used that in their analysis in coming to their decision. I forgot what I was going to say then. And one issue, and this can be a real issue, is a lack of engagement. So what do you do when you're trying to assess somebody and they just don't want to engage? How do you assess whether that's a demonstration of a lack of capacity or they just don't want to? And it can be a problem. I've seen a few cases like this recently. And again, this goes back to the explaining the purpose of the assessment, because a person who doesn't want to engage, maybe fed up of assessments, or, you know, is a bit disenchanted with the whole process, if they understand the importance and the purpose, they might be more likely to. Just a couple of cases to draw to your attention on the point of lack of engagement. There's a case, Re P from 2014, where Mr. Justice Cobb said that it seems to me that patients' lack of engagement or cooperation with the assessment may contribute in itself to a conclusion that a patient is unable to understand the information relevant to the decision, and or unable to use or weigh, but it depends on the circumstances. So there, it might be that a lack of engagement demonstrates, or partly demonstrates, a lack of understanding or a lack of an ability, but it might not. But it's something just to bear in mind when you're faced with that sort of situation. Do you think it's part of a lack of capacity? If so, why do you think that? Can you explain it? When you're looking at lack of engagement cases, you need to remember, obviously, the points of you can't determine someone lacks capacity just based on their presentation, for example, or their behaviour. So again, if you're going down this route, you need to be addressing these points, why that you've considered them, but you still consider that it's a lack of capacity for these reasons. Another case was QJ in a local authority from 2020. That was Mr. Justice Hayden again, and he considered that an aspect of P's behaviour included a reluctance to answer certain questions, but it should not be construed from that he was unable to. Now, in that case, Mr. Justice Hayden felt that there was a good deal of evidence that suggested P was doing that from choice, not an inability, but a choice. Similarly, in Wandsworth, CCG and IA in 2014, there were issues with engagement, and they actually sort of tried to work through this problem with P, and they found an assessor that P was willing to engage with. So again, that's something to think about. If you're struggling to conduct an assessment at all, what else can be done? What practicable steps can be taken? Would P be willing to talk to someone else? Is there somebody, even a GP, somebody that P has worked with before, or a type of person, a type of professional, age, gender, whatever? Is there somebody that's more likely to be able to engage than you? Of course, at the end of the day, you can't force P to undergo a capacity assessment. And in those circumstances, you will have to glean what you can from the assessments or the conversations that you've tried to have. You'll have to look at surrounding collateral evidence. You'll have to take evidence from sort of the day-to-day behaviour, how they're actually interacting, behaving. What evidence can you get from those people that deal with them on a day-to-day basis? The issue then will be if the court's prepared to accept that on the balance of probabilities, which is of course the standard here, as to whether that's a lack of capacity. But lack of engagement, I think, it can be a real bugbear. It can be a real challenge. But I think those few cases that I've just mentioned, and I'll put them in the notes and send the slides around, are some good pointers in terms of the things you need to be thinking about. And just on that takes me to the next point about remote assessments. I'm not going to read this through. This is just simply to demonstrate how the guidance on face-to-face assessments has shifted during the course of the pandemic. From January of this year, we were back to the September point, which is that face-to-face visits, for example, for DOLS assessments, are an important part of the framework, and they can occur if needed. For example, to meet the person's specific communication needs in urgent cases, or if there are concerns around human rights. And this is the sort of case where if there is a lack of engagement, for example, over a screen or a telephone, you might be needing to look at an in-person assessment. There are also other things to consider around remote assessments. And again, you know, the capacity evidence has to be the best quality that we can possibly make it. Video is obviously better than telephone in nearly all cases, but does that work for P? It's always dangerous to make any kind of generalisation. The reality is there will be a group of much older people that probably weren't particularly au fait with this kind of technology when they were capacitous, and now their capacity is in doubt. Perhaps it's even more challenging for them than for others. Would telephone work better for those people? You're going to have to look at it on a case-by-case basis. Now, I know that obviously there's been all sorts of difficulties with face-to-face assessments, not least with the guidance changing so frequently. And I know that the standard wording has been provided to put into DOLS forms around this assessment occurred at a time of a pandemic. I've tried to balance these rights against the risks of the transmission, etc., etc. And that's fine. But please don't just copy and paste that into every case. You must consider it on a case-by-case basis. Yes, for lots of cases, it will be appropriate to do telephone or video assessments, absolutely. But there will be some where it's not. So don't be caught out by just applying that that approach across the board. You've got to take everybody's individual case into account. And if you're going to do remote assessments, do you need to do more than one call? You know, is one 10-15-minute phone call enough? Do you need to try a phone call and a video? You know, you need to be a little bit more creative. Is it appropriate where you've been using remote assessments for a shorter period of authorization in the hope that you actually will be able to go out and see this person in person? You might think that that's particularly pertinent if, for example, this is somebody's first standard authorization. So all these factors have to be taken into account. If there's a very strong objection, if capacity is more in doubt, if it's more borderline, those are the sorts of cases you're likely to need to think about in-person assessments. Moving on to sort of evidence then. Social workers, you really are providing the primary evidence in the case, I'm afraid. It's going to be the basis of the local authority's case and what everyone's looking to. On a practical basis, if the matter is to go to a contested hearing, your witness statements stand as your evidence. I can see from the attendee list, we've got some very, very good and experienced solicitors in here who will support you in terms of ensuring your statements are done in the right way. But you've got to be happy with those statements. It's your evidence at the end of the day. And this is the point. You're the ones with the training, with the knowledge, the skills, the experience, the expertise. And the lawyers are not social care professionals. The official solicitor is not a social care professional. Everybody is looking to you for you to give your professional view. I feel like I'm making it sound really fresh and I don't mean to. But I suppose what I'm getting at is be confident in your knowledge and your skills. That's what you're here to do. That's what you're doing on a day-to-day basis. And that's why we're looking to you to inform us. You know, you're the one that has hopefully visited P. You're the one with the knowledge of the care system. You're the one with the knowledge of how these conditions or these things can change and deteriorate as to what's happened in the community before, for example. So you've got the opportunity to address all of these issues. And if you're able to do them in a comprehensive and robust way, you're more likely to reach a point of agreement in terms of P's representatives saying, all right, okay, well, the social worker said that, they've done these assessments, we've looked at alternatives, this is the social worker's view, okay, I don't like it, but I see the point. So in terms of your evidence, your witness statements, and this is likely to be ordered at that first attended hearing or the agreed order for that, get your detail in first time. The number of cases, it's probably the majority of cases, to be honest, where the social worker does a statement and then P's representatives want something else addressed and something else and something else. And this goes back to something I said much earlier around, you know, having that liaison, setting the parameters, being clear, be demanding of P's representatives. What is it that they want you to do? Let's be clear. Let's not leave this open to, you know, going down every single possible little ginnel we can think of. What are the parameters? What are the issues in this case? What evidence is needed? And I think the courts are going to be much more supportive of that position. They're not going to want to see these cases carry on taking a year or more. They're not, you know, they're under pressure almost now from Hillingdon. It's got to be a speedy review. These are interim orders to allow us to make a determination. So let's set out what that's going to be. let's apply the principles and let's explain, because I think this is, again, perhaps one of the little traps people have fallen into. I know that virtually every social worker has those principles in their mind when they're drafting this evidence. They've, in their minds, applied least restrictive option, presumption of capacity, best interests. I've consulted these, I've taken into account all the relevant circumstances. If it's not on the paper, we don't know that you've done that. And I know it's a lot of work, but if you put that work and that time in for the first statement, you're saving yourself so much more in the longer run. Show that you've identified the principles, show how you've applied them, show what your rationale is. Give us a list in terms of your balance sheet, that's fine, but highlight which are the factors which you thought were particularly important. Why have you come down on that side? You may think that points A and B, outweigh anything else, or the factor of magnetic importance. But if you can explain it in detail at this stage, like I say, it's so much better for the long run. But it's also useful to consider the other side in terms of, I have considered whether, so for example, extra care has all these benefits. Yes, it's these downsides. You may think that going home is just not realistic, it's just not viable. Fine, but explain it. Don't just say in a sentence, it's not viable. Tell us why. Tell us that it's because of the history or the level of need or the 15 phone calls a day that were being made to family members or the number of times 999 was being called, whatever it is. Tell us why it's not a viable option. It should be a fairly substantial piece of work, so give yourself time. Ask your managers for time if you need it. Tell the other side, no, you can't do it in 2 weeks, you need 4 or you need 6. It's much better for everybody if that evidence, when it comes, is comprehensive. It's what everyone wants, it's that level of detail. And if it takes another 2 weeks, that's preferable to sort of partial statement, not quite enough time to do the full analysis that you'd like to, and then you're off again to bolster it or to add something to it. In terms of contested hearings themselves, they're actually quite infrequent. It's actually not that uncommon to have Section 21a cases where you never see the inside of a courtroom to agree what evidence is needed, provide that, have roundtable meetings, and actually come to agreement. That's fairly common. But it does sometimes go to a contested hearing. In my experience, that does tend to be more likely where there are family members who are parties and there's disagreement amongst family members. I'm just thinking of the last 3 days that I've had one of those. As I say, your statement is your evidence in chief, and you will be cross-examined on it if you get to a contested hearing, but whoever's representing you should talk you through this in terms of what to expect. Your opinions will be tested, probed, explored, potentially challenged. That's fine. That's not a personal attack on you. None of this is personal to you. I can absolutely assure you of that. And it probably doesn't feel like it if you're in the witness box, but it's not. It's absolutely not. But you'll have representatives probably of P. You could have family members in person because there's no legal aid in these cases unless you're P or the RPR. So if you've just got family members, and this can be quite difficult to be asked questions by angry family members, different approaches are taken. Some of it will be fairly, as I say, exploring on a professional level. It can be more challenging if it's a family member. But that's something that as I say, that your solicitors and barristers should talk to you about at the time. In terms of oral evidence, always have the most recent up-to-date information. Make sure you've spoken to P and or the care home shortly before the hearing. Be measured, don't be angry. This isn't personal. We're asking you what your professional opinion is. We might be exploring it. We might be testing it or probing it. That's fine. Don't feel defensive. I know it can be hard, but really try not to be. Concede where appropriate. maybe you could look at it a different way. And again, that doesn't mean that you're wrong. It doesn't mean you've made a mistake. If someone suggests that you could look at something differently and you think, oh, actually, then say so. It will just show that you are able to reflect on changes or reflect on information. So that don't ever think that that's a weakness. But having said that, stand by your position if that's what you think, and don't be afraid to disagree with whoever's asking you questions. You're perfectly entitled to do that. And on that point, when it comes to evidence and the opinions of experts or social workers or whoever, the expert advises, but the court decides. And ultimately, for example, in respect of both capacity and best interests, it's for the court to decide. And there's a number of cases, Mr. Justice Cobb in WBC and Z and others, he set out again that the roles are distinct. So the expert advises and the court decides. And while the opinion of an independent instructed expert is likely to be of considerable importance, the decision as to capacity is a judgment for the court. So this is just an example, the case of ReFX from a few years ago. This was a case where there was a dispute as to capacity in a young man that had Prader-Willi. And we had in that case probably the leading expert on Prader-Willi who said that P lacked capacity. And we had a local authority social worker saying, well, actually, I think he has capacity. And the court found that the social worker had started from the correct point of the presumption, that the social worker had properly applied the principles of the MCA. The social worker had reflected and balanced the evidence and the conversation she'd had, and ultimately her evidence was preferred over this leading expert. So, you know, you are experts in your own right. You're not court-appointed experts, but, you know, you're highly trained, skilled individuals, and your opinion matters. So please don't ever think otherwise, even if we're asking you difficult questions. We're all looking to you for answers. So I hope that's been helpful in terms of some of the issues that might arise and some tips. I've gone just over an hour, but if anybody does want to put any questions in the chat, I'm happy to hang around for another little while. But thank you very much for your attendance. If you would like the slides, I can add in some of those additional cases that I've mentioned during the course of the talk and have them sent round to you. Obviously, we've got your email addresses from your registration. So as I say, if you've got any questions you'd like me to try and deal with now, please put them in the chat. Don't all rush at once. Yep, okay, yeah, just a couple of requests for the slides. As I say, I will pop those additional cases on and have those sent round to you. Well, I can't see any questions coming in at the moment. I'll hang around, as I say, for another 5 or 10 minutes in case anything occurs to anyone. But otherwise, thank you very much for listening to yet another Zoom talk. And hopefully we will get a chance to see each other in person in the not too distant future. Thank you.